morning, the US Supreme Court has ruled that Donald Trump has some immunity from prosecution for official actions taken while he was in the White House. The landmark decision is likely to delay his trial for interfering in the 2020 election. The former president described the decision as a big win. Our North America editor Sarah Smith reports.
The powerful Supreme Court has the final say on what presidents can and cannot do. Today's historic ruling means a president can never be prosecuted for anything that's part of their official duties, but they do not have immunity for non-official acts. So what does this mean for the criminal cases against Donald Trump?
Fight for Trump! Fight for Trump!
When he spoke to supporters on January the 6th, was he officially acting as the president or as the losing candidate?
We fight like hell, and if you don't fight like hell, you're not going to have a country anymore.
Donald Trump is facing criminal charges related to the January the 6th riot and attempting to overturn the election.
Here's what strikes me every time I read this ruling. The people celebrating it understood exactly half of what the Supreme Court actually did, and the people condemning it understood the other half. Almost nobody is holding both halves at the same time. And until you do, you don't actually understand what the court built, what it deliberately left open, or why the reverberations from this decision are still reshaping every branch of the federal government 2 years later. This is not a story about Trump winning. It's not a story about Trump losing. It's a story about the Supreme Court constructing a legal architecture with one hand while drawing a permanent map of vulnerability with the other, and then handing both documents to a political system that has largely proven unwilling to read either one carefully. My name is Matthew John Turner. I've been tracking the downstream consequences of Trump versus United States since the day the opinion dropped. And what I want to do in this video is give you the precise, layered picture of what this ruling actually decrees. Not the cable news shorthand, not the partisan victory lap, not the alarmed op-ed that stops 3 paragraphs in. The actual structure, the actual consequences, and the actual question that nobody in Washington has answered yet, which is the one that matters most going forward. Let's get into it.
President Trump's attorneys are pushing the Supreme Court to endorse a huge expansion of presidential power. An ABC News review finds nearly a third of Trump's unprecedented 29 appeals to the high court in a second term have invoked the monumental 2024 immunity case. Legal analysts also say they see its influence in how the president is pushing for the prosecution of enemies and dropping charges against allies. On Monday, the Supreme Court justices cleared the way for contempt of Congress charges to be dropped against former Trump advisor Steve Bannon. Now legal experts say these appeals could shape how much power a president can exercise and how far the courts are willing to go. ABC News senior Washington reporter Devin Dwyer has the latest. So Devin, how big of a deal are these findings and what does this say about Trump's presidential power?
Well, we're 2 years now, Perry, since that immunity decision, and we're seeing its long reach. Remember, in 2024, the Supreme Court gave Trump immunity from criminal prosecution. But one of the things it also did was it enshrined in the text of the opinion.
Ruling nobody fully read. Let me start with the structure of the decision itself, because the architecture is where the analysis has to begin. The Supreme Court did not hand Donald Trump a blank check. The commentary you heard in that clip, near unlimited immunity, the fortress has no roof, is accurate as far as it goes, but it doesn't go far enough in either direction. What the court actually constructed is a 3-tiered system of presidential exposure, not one rule. 3 distinct categories with 3 distinct legal standards, and the failure to distinguish between them is responsible for most of the confusion, driving both the victory laps and the alarm bells. Tier 1. Absolute immunity. The first tier covers the core constitutional prerogatives of the executive branch, issuing pardons, commanding the armed forces, directing the Department of Justice, executing federal law. For actions within this category, the immunity is absolute and unreviewable. A president exercising these powers cannot face criminal prosecution. The court was explicit and unambiguous on this point. Here is where it becomes significant, and where Justice Sotomayor's dissent carries weight that has only increased with time. The court's reasoning for absolute immunity in the DOJ communications context is that the president is the chief law enforcement officer of the United States. Directing the Justice Department is a core constitutional function. Therefore, instructing the Attorney General to open an investigation, even one predicated on demonstrable falsehoods, even one motivated by corrupt political interest, falls within the cordoned-off zone of unreviewable executive discretion. Read that again slowly. A president can direct the Department of Justice to open an investigation based on known falsehoods for purely partisan political purposes and face no criminal liability for doing so. The court did not just protect the presidency from prosecutorial overreach. It immunized conduct that, in any other institutional context, would constitute an abuse of power clear enough to land a private citizen in federal court. Justice Sotomayor's hypothetical that a president could theoretically order a military unit to eliminate a political opponent, dress the order in the language of a national security directive, and walk free from criminal accountability, was dismissed at the time as hyperbolic. The problem is that the legal logic of the ruling does not cleanly foreclose that reading. And in a political environment where the domestic deployment of military assets and the characterization of political opponents as enemies from within are active policy conversations, the hypothetical has stopped feeling theoretical. Justice Jackson described the ruling as breaking new and dangerous terrain, creating a gap in the rule of law that had never previously existed. These are not partisan talking points. These are formally reasoned objections from two of the most legally rigorous minds currently sitting on the federal bench. They deserve to be engaged on the merits, not dismissed as alarmism. Tier 2. Presumptive immunity. The second tier covers official presidential acts that don't fall within the absolute core, actions that are governmental in character, but not strictly part of the exclusive constitutional toolkit. The court says the presumption runs toward immunity here too, but that presumption can theoretically be rebutted. The operative word is theoretically. The evidentiary bar the court set for rebuttal is, as lower court judges have discovered in the subsequent 2 years, so high as to be functionally prohibitive. The government must demonstrate that allowing criminal prosecution would impose no chilling effect whatsoever on the functioning of the executive branch. No chilling effect whatsoever. That is not a rigorous evidentiary standard designed to be met. It is a standard designed to signal that this category should, in practice, mostly function like the absolute tier above it. The practical consequence of this has been visible in the fate of the federal election subversion case. The district court tasked with sorting through the conduct was asked to determine whether pressure applied to Vice President Pence to disrupt the certification of electoral votes was an official act or a private political act, whether calls to state officials, the Georgia Secretary of State call asking to find votes, were acts of the presidency or acts of a political candidate. That determination has become so legally contested, so resource-intensive to litigate, that the process itself functions as a win for the defense regardless of the ultimate legal outcome. And of course, the entire proceeding became moot when the sitting president doctrine was invoked after the 2024 election. The federal case didn't end with a judicial exoneration. It ended with a procedural dismissal triggered by electoral outcome. The accountability mechanism was not defeated on the merits. It was outrun by the calendar. Tier 3, zero immunity, and why this is the part that still has teeth. The third tier is where the analysis gets genuinely important for what happens next, and it is the tier that has received the least sustained analytical attention relative to its actual legal significance. For unofficial acts, private conduct, personal financial dealings, non-governmental schemes, behavior undertaken as a private citizen rather than as commander-in-chief, the immunity is exactly zero. The court's language on this point was not hedged, it was not presumptive, it was a declaration. No immunity for unofficial, private, personal acts. Full stop. The New York conviction sits on this tier. 34 felony counts for falsifying business records in connection with a hush money payment. The checks came from a personal account. The reimbursement scheme ran through a personal attorney. The falsified ledgers belonged to a private business entity, not a government office. None of that conduct has any discernible connection to the constitutional duties of the presidency. The Supreme Court's immunity shield does not extend 1 inch over that legal terrain. The conviction stands, and the ongoing appellate process, while grinding forward on separate technical grounds, cannot invoke the immunity ruling to simply erase the record. The broader implication that legal scholars have been carefully noting is prospective. any future investigation or prosecution centered on private business conduct, personal financial arrangements, or relationships and associations that occurred outside the timestamped bounds of official presidential duty operates in a legal environment where the 2024 ruling provides zero protection. The court didn't just preserve existing exposure. It drew, in the court's own language, a permanent, explicit boundary showing every state prosecutor and congressional investigator exactly where the fortress walls end and the open field begins. What the ruling did to Congress, and what Congress has done with it, here is the part of this story that I think is most consequential and least understood, and it requires stepping back from the legal architecture to look at the structural shift in how accountability is now supposed to work. When the Supreme Court effectively immunized the vast majority of official presidential conduct from criminal prosecution, it was not operating in a vacuum. The court knows that accountability for executive power has to live somewhere in the constitutional system. Criminal prosecution is one mechanism. It is not the only one. And the ruling, read carefully, sends an unmistakable institutional message to the legislative branch. The message is essentially this: we have closed the criminal courtroom door for official acts. If the American public wants accountability for how presidents exercise official power, the Constitution provides tools for that, and those tools belong exclusively to Congress. Impeachment, robust oversight, the power of the purse, the War Powers Resolution, enforcement of subpoenas. These are not supplementary options. Under the architecture the Supreme Court has now constructed, they are the primary mechanisms of accountability for the exercise of official presidential authority. That realization has collided with a Congress that is, institutionally and temperamentally, deeply reluctant to use its most extreme powers. For years, and I want to be precise about this because it matters for understanding the current moment, the theoretical possibility of post-presidency criminal prosecution served as a background deterrent, not an active threat in most cases, but a presence. An awareness that the full exercise of presidential power might eventually face judicial scrutiny after the office was vacated. That deterrent has been functionally eliminated for official acts, and its elimination has exposed something that was always structurally true but easy to overlook when the judicial backstop existed. Congress has an accountability deficit that it has been quietly outsourcing to prosecutors for decades. The recent wave of impeachment filings, covering foreign entanglements, domestic military deployments, immigration enforcement tactics, cannot be accurately characterized as pure political theater. Some of it is political theater. But structurally, these filings are a direct response to the vacuum the court created. If criminal prosecution is removed as a consequence for official acts, then a Congress that refuses to exercise its impeachment authority isn't exhibiting legislative restraint. It is effectively endorsing the proposition that for the full universe of official presidential conduct, there is no accountability at all. A congressman who scoffs at impeachment articles while voting against any oversight mechanism is not being institutionally cautious. They are writing a blank check in silence. The shield and the leash, a paradox that hasn't been resolved. Here is the piece of this story that genuinely confounds the simplistic framing that the court just handed Trump unlimited power. It hasn't. The same conservative majority that constructed the immunity fortress has, with notable consistency, been issuing rulings that constrain the boundaries of executive action in the second term. Environmental and tariff policies struck down as unconstitutional usurpation of congressional authority. Attempts to federalize state National Guard units blocked without proper authorization. The Major Questions Doctrine applied to prevent sweeping agency restructuring without explicit congressional approval. This is the same bench, the same 6-3 ideological configuration, some of the same justices whose appointment histories are intertwined with the very administration they are simultaneously shielding and constraining. And what they have built is a legal paradox that nobody in the administration has fully stress-tested yet. They have said, you are immune from prosecution for official acts, and you are constitutionally prohibited from taking many of the actions you want to take. Legal analysts have called this the shield and leash dynamic. You are protected from legal consequences for what you do, but we will stop you from doing it in the first place. That framework generates a question that the current political environment is going to force into the open sooner or later. If a president is immune from prosecution for an official act, but the Supreme Court has ruled that act unconstitutional and ordered it stopped, and the administration ignores the order, what happens next? The criminal justice system cannot touch him for the act. The immunity is established. So who enforces the court's injunction? The answer the court's entire body of recent jurisprudence points toward is Congress. The courts issue the ruling. The Congress must supply the political consequence for ignoring it. And we are back, again, to a legislature that has demonstrated consistent unwillingness to exercise its most consequential constitutional powers. This is not a theoretical problem on the distant horizon. Federal judges have already found the administration in contempt in the immigration enforcement context. The question, so what? The enforcement question is live and active right now. The deterrent that used to supply the so what for an official act of contempt was the specter of future prosecution. That specter is gone. The replacement deterrent is supposed to be impeachment. The gap between those two mechanisms, one now absent, one largely unused, is where the constitutional fire on Capitol Hill is actually burning. The dissents as a user manual, I want to spend a moment on the dissenting opinions because 2 years out from the ruling, they are aging in a way that warrants serious attention. Justices Sotomayor and Jackson wrote dissents that were, at the time of publication, treated in significant portions of the media as partisan alarmism. The vivid hypotheticals, the assassination of a political rival through an official directive, the prosecution of enemies dressed in the language of legitimate law enforcement, were characterized as overwrought by commentators who found the majority opinion more measured than the dissenters' alarm suggested. That characterization looks different now. Not because the hypotheticals have been realized, they haven't been, and it's important not to conflate the warning with the event, but because the legal and political context in which they were offered has shifted enough that the gap between hypothetical and proximate concern has visibly narrowed. Debates about domestic military deployment, the characterization of political opponents as national security threats, and the mechanics of using the DOJ to investigate perceived enemies are not abstract conversations happening in law review footnotes. They are active news cycles. The dissents provide the foundational legal and moral architecture for every accountability mechanism currently being attempted in Congress. The 25th Amendment letters, the impeachment articles, the war powers resolutions, the subpoena enforcement efforts. The majority opinion wrote the new rules of the game. The dissents wrote the manual for playing under those rules while preserving as much of the accountability structure as the ruling left intact. The Epstein files and the unofficial acts corridor, there is one additional dimension of this ruling's reach that belongs in this analysis because it illustrates precisely how the unofficial acts framework functions in real political time. The bipartisan effort in the House to subpoena the Epstein sealed records, with allegations involving private conduct and personal associations that have been categorically denied, is a case study in how the court's third tier operates. Whatever the ultimate factual content of those documents, the legal framework for assessing any conduct they might reveal runs directly through the unofficial acts corridor. Behavior that occurred outside the strict time-stamped bounds of official presidential duty is, by the court's own explicit declaration, entirely outside the protection of the immunity ruling. The ongoing appeals in the New York hush money case exist in the same zone. The Supreme Court itself has designated the entire domain of private, unofficial conduct as open to legal and political scrutiny. The bright line the court drew is not a suggestion. It is a jurisdictional boundary with constitutional force. And everything on the unofficial side of that boundary, private dealings, personal financial arrangements, non-governmental associations, sits in a legal environment where the 2024 ruling offers no shelter whatsoever. Let me pull this together because I want to leave you with a precise picture rather than a mood. The Trump v. United States ruling is a paradox of legal architecture. And I use the word paradox deliberately, not as a rhetorical flourish. The court built a ceiling of protection over official presidential conduct that is, in the absolute tier, genuinely breathtaking in its scope. It also built a floor of vulnerability under private, unofficial conduct that is equally clear, explicitly declared, and still legally active. The hush money conviction sits on that floor. The civil judgments sit on that floor. Whatever emerges from ongoing private conduct investigations will sit on that floor. The ceiling is real. The floor is real. The man is sometimes operating with near monarchical immunity for official acts, and sometimes operating as a private citizen with zero special protection from the law. The court published the map showing exactly which is which. That map is a matter of public record. What the ruling did to the accountability structure is in some ways more consequential than what it did to Trump's personal legal exposure. By eliminating criminal prosecution as a deterrent for official acts, the court has placed the entire weight of executive accountability on a Congress that has spent years demonstrating institutional reluctance to carry it. Every tabled impeachment resolution, every ignored subpoena deadline, every contempt finding without enforcement consequence, each one of those is a data point in the same direction. The constitutional design requires political will to function. And right now, the supply of that will is not meeting the demand the court's ruling has created. Justice Sotomayor and Justice Jackson wrote warnings that were dismissed as alarmist. 2 years later, those warnings are the most accurate description of the operational environment available. Not because the worst scenarios have occurred, they haven't, but because the legal framework those scenarios would require to unfold is now formally in place. The warning label is on the bottle. Whether anyone reads it before something goes wrong is a political question, not a legal one. Here's what I want you to sit with. The Supreme Court has done its part. It drew the lines. It published the map. It told Congress, this is your problem now. The question is not whether the legal architecture exists to hold this administration accountable for unofficial acts. It does. The question is whether the political system has the will to use the tools the Constitution actually provides for official ones. That's not a rhetorical question. That's the central accountability question of this political moment. And the answer is being written right now, in committee votes, in subpoena enforcement decisions, in whether the oversight battles currently consuming Capitol Hill produce consequences or just noise. If you've been following this ruling and want to understand the downstream legal fights as they develop, the appellate decisions, the contempt enforcement questions, the war powers confrontations, stay on this channel. This story is not in the past. It is the structural frame around everything happening in Washington right now. This is Matthew John Turner. The record is public. The lines are drawn. Whether they hold is up to the people elected to hold them,